Okay, I think we have everybody or darn close, so let's get started. We'll open the hearing on Senate Bill 58 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 58, sorry, let me put that in front of me, prohibits the filing of certain liens or claims against real or personal property, and it provides criminal penalties for people who do so. So new section 1 would be part of the criminal code. It would make it unlawful for any person to present for filing in any public record any lien or claim against any real or personal property when that person knows or reasonably should have known that the lien is false or contains any materially false, fictitious, or fraudulent statement or representation. It would also be unlawful to present for filing in any public record any document that purports to assert a lien against real or personal property of any person or entity that's not provided by law. Present for filing in any public record any financing statement pursuant to Article 9 of the UCC when that person knows or reasonably should have known that it's not lawful to do so, or to present for filing in any public record a document filed in an attempt to harass an entity, an individual, or a public official, or obstruct a governmental operation or judicial proceeding when that person, again, reasonably knows that information or that filing contains false information. It would also be unlawful to violate a court order issued pursuant to KSA 584301, and violation of this new section would be a severity level 8 non-person felony. Section 2 amends KSA 584301. That's the statute that provides for an expedited process to review and determine the validity of liens and claims against real or personal property. In that statute, under current law, a person can file a motion for judicial review of documentation or an instrument purporting to create a lien or claim if they believe that the documentation or instrument is fraudulent. The court can make findings of fact and conclusions of law. And those include an order setting aside the lien and directing the filing officer to nullify that lien instrument. This bill would add a provision requiring that if the court orders that lien or claim to be set aside, then the court's findings of fact and conclusions of law would also have to include an order prohibiting the person who filed that lien or claim from filing a future lien or claim with any filing officer without first getting approval from the court that entered that order. And it would also have to include a provision stating that a violation of the order could subject the party to criminal and civil penalties. Section 3 amends KSA 584302, which provides that after a court has made a finding that a lien or claim is fraudulent under that statute, KSA 584301, the aggrieved person can bring a civil action for damages and injunctive relief against that person who filed those fraudulent documents. Current law provides that violation of an order or an injunction under that section could be punishable with civil or criminal penalties. This bill would preserve the civil action, but the punishment for violations of the order would be under that new section that's created under the crime in Section 1. And I can take any questions.
Thank you, Natalie. Representative Carmichael.
Thank you, Mr. Chairman. Ms. Scott, I don't think that we've seen this type of legislation recently, have we?
Mr. Chairman, Representative Carmichael, you have not, but the Senate has for the last 2 bienniums. So in 2017, 2018, you could look at Senate Bill 10, and then in the last biennium, Senate Bill 372.
Thank you. I do have also a question about the prohibition of a party who's violated this statute filing additional liens or claims. I think it does provide for a court order that requires some type of advance clearance before that party can file additional liens or claims. Did I understand that correctly?
Yes, Mr. Chairman, that is the case. If you look at page 3, really, you'll probably want to look at the bottom of page 2 to get that lead in. But it does also include a requirement that the court's findings of fact and conclusions of law have to include an order prohibiting that person from filing any future lien or claim with any filing officer without approval of the court that enters that order.
And Is that prohibition limited to the judicial district where the lien was filed, or would it have statewide effect? And if it has statewide effect, does it require the party who's under that restraint to go back to the first court and get permission to file a lien or a claim in some different district court?
Mr. Chairman, and I hope the proponents will correct me if I'm wrong in my reading of this, but it does say that it prohibits that person from filing a claim with any filing officer. And then it says without approval of the court that enters the order. So I think they would have to go back to that court to get permission. But again, I hope the Attorney General's office can correct me if I'm wrong on that.
Thank you very much. I appreciate your help.
Any further questions for Natalie? I do not see any, so we will begin with our proponents, and first up is Steve Phillips.
Can you hear me?
Yes.
My name is Steve Phillips. I'm an employee of Kansas Attorney General Derek Schmidt's office, and I'm here to speak on behalf of the office in favor of Senate Bill 58. Senate Bill 58 is intended to strengthen Kansas's statutes concerning bogus or fraudulent liens. These are liens that are filed solely with the intent to harass public officials, employees, judges, law enforcement officers, county officials. The people that file these generally fall into two classes. They're people who have been convicted of crimes and seek retribution against the prosecutors and judges, or they are people who do not recognize the legitimacy of our current system of Kansas government, so-called sovereign citizens. Bogus liens have been an ongoing and continuing problem. As Judge Gehring will address, within the last year, we had to file an action to lift bogus liens against 2 Sedgwick County judges and the court clerk. In the past, I remember a lien being filed against a judge who was getting ready to sell her house, and it set her into kind of a panic. There is a statutory mechanism in Kansas, like many states, for expedited judicial review of bogus liens. And that works well enough to get rid of that lien, but it does nothing to deter future filings by the same person. To try and stop repeat filers, and we have had some frequent filers, in 2010, the legislature added a provision allowing for damages against the filers. While that legislation was well-intentioned, it suffered from the flaw that most of the rogue filers are judgment-proof. In other words, the threat of damages is no deterrent against them. So Senate Bill 58 proposes 2 things. It makes it a crime to knowingly file a false lien. Of course, a conviction would require a separate criminal charge and trial brought by the county or district attorney or the Attorney General's office. And then secondly, as mentioned, it contains a provision that the court must include an order prohibiting the rogue filer from any future filings. And in answer to the question, my reading of the bill also is that it would be a statewide prohibition with any filing officer, and the person would have to go back to the judge or the court that issued the initial order prohibiting filing for permission. I appreciate the committee's time and consideration of this proposal, and I'd be glad to answer any other questions.
Any questions, committee? Not seeing any. Thank you. We will move on to Judge Gehring.
Thank you, Mr. Chairman, and thank you, members of the committee, for allowing me the opportunity to speak in favor of Senate Bill 58. I won't repeat much of what Assistant Attorney General Phillips just said. As indicated in my testimony, this isn't just a hypothetical. This has happened to me and another judge in Sedgwick County. Last year, one of our criminal judges was presiding over a criminal matter. The mother of the litigant wasn't happy with the rulings that she was getting from the judge, and she wasn't happy with me for not doing anything about the judge who was issuing the rulings. So consequently, she filed a fraudulent lien against my home, against Judge Brown's home, and against the home of our 18th Judicial District Court clerk. We do have a very cooperative register of deeds who went out of their way to tell me about the fraudulent filing, but keep in mind that register of deeds office aren't required to do that. And many times the person that has the fraudulent lien filed against their real estate won't even know that the lien is there until you get to the point where trying to sell your house and a title search would come up and find these liens, at which time it's sort of inconvenient and a hassle to quash. And while current law does provide for a relatively efficient way to clear your property of the fraudulent lien, it really has no teeth to prevent the filers from this tactic, which has become a favored tactic of certain groups, as Assistant Attorney General Phillips alluded to. I think as long as there is no real consequence for this, and although current law provides for the recovery of fees and the pursuit of a remedy through civil suits, the long and the short of it is, as Attorney General, Assistant Attorney General Phillips indicated, these individuals are 9 times out of 10 judgment proof. So whatever judgment, whatever civil relief you obtain is sort of a worthless remedy on your part. And these individuals know that. And so as long as there is no real long-term consequence for engaging in this activity, it will continue and likely increase. Thank you for the opportunity to address the committee, and I'm happy to stand for questions at the appropriate time.
Thank you, sir. Committee, any questions? I'm not seeing any, so we will move on to our next conferee. Let's see. Oh, I see Scott Schwab on here, but I think that's actually Katie. So let's go with Katie.
Yes, sir. Thank you, Mr. Chairman. I'm Katie Kopal, Deputy Assistant Secretary of State for Communications and Policy. I will be very brief, as the previous proponents did a great job. Our office supports Senate Bill 58 as we believe it will be a useful tool to help reduce fraudulent Uniform Commercial Code filings. Currently, we do not have a recourse to address such fraudulent filings in our office. Our role is purely ministerial, and filings that may be or appear to be fraudulent often meet the basic filing requirements. So we must file those documents because it is a core tenet of the UCC and state law that if certain minimum requirements are met, we must file it. As the Secretary of State for the state of Kansas, our office receives millions of filings a year. And again, we believe Senate Bill 58 would be a helpful tool to help deter these fraudulent filings. Kansas would join at least a dozen other states to make it a crime to fraudulently submit a filing, and we appreciate your consideration of our testimony today.
Any questions? Not seeing any. Thank you, Katie. We will now move on to Sheriff Easter.
Good afternoon, Chairman and committee members. This is Jeff Easter with the Kansas Sheriff's Association. I'm also presenting testimony for the Kansas Association of Chiefs of Police and also the Kansas Peace Officers Association. I'm not going to add anything more than what's in our written testimony and what you've heard from Judge Goering and the Assistant Attorney General of what happens, especially with property owners when they find out there's a lien. It's usually when they're trying to sell a home, and then it causes a lot of issues. The two things that we absolutely support in the bill is the provision of the bill that attempts to stop a person from continuing to file their fraudulent filings. This is accomplished by requiring court approval to file future liens once a lien person has been filed. It's found to be fraudulent. So we believe that this is for anywhere in the state, to answer Mr. Carmichael's question. The second is to create a criminal penalty for knowingly filing a false lien. We believe that that could be a deterrent from these individuals who maybe have filed one and then continue to try to file more. So with that, I'll take any questions that you might have. Thank you for your time.
Very good. Any questions? Don't see any. Next, we will move on to Amanda Stanley, who is here live in person a few minutes ago and darted across the street to join us online.
Thank you. Thank you, Mr. Chairman, for allowing me to testify. I won't add to what the other conferees have said. They've done a great job explaining this. I just would like to note that we have heard concerns from several years here at the league from city managers and city clerks in parts of our state where there is a huge segment of sovereign citizens in that area with concerns about this particular issue. So we do think 58 will help address some necessary concerns across our state and stand in support of it. I'm happy to answer any questions.
Any questions? Don't see any. Thank you, Amanda. Is there anyone else here as a proponent? Okay, what about any neutral conferees? Any opponents? Not seeing any, so we will close this hearing on Senate Bill 58, open the hearing on Senate Bill 60, and have Natalie give us an overview.
Thank you, Mr. Chairman. Senate Bill 60 defines proximate result for purposes of determining when a crime is committed partially within this state. So the bill amends KSA 21-5106. That's the provision in the criminal code relating to jurisdictional application and issues. Under current law, one of the ways that a person is subject to prosecution under Kansas law is if the person commits a crime wholly or partly within the state. And one of the ways to commit a crime partly within the state is if the proximate result of that act occurs in this state. The bill would define proximate result for these purposes as any logical effect or consequence of such act, regardless of whether the statute governing the charged offense considers the specific effect or consequence of such act. I would note, and you'll see there in my brief, that this language would directly overturn a holding from the Kansas Court of Appeals, and you can see some of that information. I'm sure the Attorney General's office is going to get into that, but I can take any specific questions you have.
Do we have any questions for Natalie? Boy, no questions today. Okay, we'll move on to proponents, and we have one listed, Chris Ailsliger, or however I should say that. Chris, please correct me.
Ailsliger, it's fine. You got it close.
Very good. Well, thank you. Thanks for being here.
Thank you very much for having me. Yeah, the Attorney General's office supports this bill. It is essentially a correction to a judicially created constraint on our existing law. The statute has long been in place that allows us to prosecute for criminal acts that occur outside of the state but have approximate result within the state. But a recent Court of Appeals decision in a case called State v. Roselle put a restriction on that is not in the plain language of the law. But what the Court of Appeals held was that the specific criminal statute that was being prosecuted had to specifically contemplate whatever the negative effect or result was that we were using to confer jurisdiction. And in the case that that was at issue, Mr. Roselle was involved in a traffic accident with a Kansas resident, but on the Missouri side of the border in the Kansas City metro area. He then submitted a fraudulent claim for medical expenses against that Kansas insurance policy, but he did everything from outside, from the Kansas City, Missouri side of the border. And the Court of Appeals held that we couldn't prosecute him because the fraud statutes didn't specifically contemplate that specific effect of a fraudulent act on an insurance policy. And we submit that no statute could be written to contemplate every single potential negative effect of an out-of-state criminal act. And quite honestly, before this decision, that was never the law in Kansas or nationally. As I put in the written testimony, as far back as 1911, the United States Supreme Court held that states could constitutionally prosecute criminal acts that occur outside of the jurisdiction as long as those acts produce detrimental effects within the state. And that's what we believe that was the state of the law in Kansas until the Roselle decision. And then the Roselle decision, for whatever reason, put that additional restriction on there that really hampers our ability to prosecute out-of-state actors for things that occur or that have a detrimental effect in Kansas, such as in this case, insurance fraud and false writings. But you can imagine potential other or other situations, especially involving the internet and cyber crimes and so on, that where the criminal actor remains outside of the state the entire time, and yet his criminal acts have a detrimental result in Kansas. But with this Court of Appeals decision, we're kind of hamstrung in prosecuting those. So we support changing the law and just altering the language to make it clear that proximate result doesn't have any specific technical meaning other than its plain language, which is just a logical effect or consequence of the act. And I will finish with that and stand for questions.
Thank you. Representative Carmichael.
Thank you, Mr. Chairman. Mr. Alslager, how do I say your name? I'm sorry.
Alslager.
Alslager.
I answer to anything close. I don't even know how to say it anymore. So,
well, I've read your name many times and I just haven't had to pronounce it before. In looking at the court's docket, it looks like that review was granted by the Kansas Supreme Court, and that your closing brief, I think, was filed about January 20. And so you are, of course, expecting to see the Kansas Supreme Court overturn this decision of Chief Judge Arnold Berger, which you believe to be erroneous. Do I understand that correctly?
That is correct. We did seek review, and it was granted. But we don't. I mean, we don't know how that's going to come out, and we really believe that we believe the Court of Appeals was wrong. But if the Supreme Court for some reason was to agree with them, then we would have to wait till the next legislative session to try to fix this. And we think that this is a really it's an important issue, especially with the amount of out-of-state fraud with unemployment claims and so on that have been going on. That we need to have tools. We need to be able to prosecute those people that commit those acts that have an effect within Kansas. And so I guess I would say that yes, we are seeking review of that decision, but there's no timetable on when that would be heard by the court. There's no timetable on when that decision would come out, and of course we can't see into the future as to what the court is going to decide. So our office felt it best to cover all the bases and seek a change in the law so that it's not left up to the courts to determine.
Can we agree, sir, that the decision of which you complain, State versus Roselle, is not a binding precedent in Kansas, and it has no precedential value unless and until the Kansas Supreme Court rules in this matter? Can we agree?
That is technically true. Although, as I found, even cases that are under review tend to have persuasive value nonetheless. But yes, you are correct. It is currently not binding.
I don't believe they even have persuasive value, but we could take that up perhaps at another time.
They shouldn't. But
you believe that judges violate their oath and they
no, that's
lend
not what I said.
persuasive effect to decisions that are not binding precedents. Come on, I'll withdraw the question.
But the argument, the position is it could be persuasive. So our office has felt like the best way to fix this is to make sure the law is clear.
And of course, you recognize that in the decision in front of Chief Judge Arnold Berger, she in several different instances, frankly, criticizes your briefing in this case because she says you failed to address the issues that needed to be addressed. And of course, a trip to the Kansas Supreme Court will allow you to either point out that she was in error or to address those additional arguments so that justice is done. True?
Yes, that's true. That is what the court said.
And then vis-a-vis the facts in this particular case where you feel aggrieved, as I understand it, the accident occurred in Missouri. The defendant was in Missouri. He made a false writing, arguably made a false writing in Missouri, and he sent that false writing to Tennessee. And I think the Court of Appeals observed that he's certainly liable for prosecution in both Missouri and probably Tennessee because there is the necessary nexus. The act was committed in Missouri, and the proximate result was a fraudulent claim that arrived in Tennessee. Did I understand the court's decision correctly in that regard?
Again, that's technically correct, but there are some practical obstacles to what the court suggests. In Missouri, the Missouri prosecutors have already got a full caseload. They're already as overworked as Kansas prosecutors. Without a Missouri victim, they're not particularly inclined to pursue that. As far as going after, this is a problem of the modern age where, insurance companies, a lot of companies, they've reverted to call centers, right? So all of the claims go to a certain place. So now you would be asking the local prosecutor in Tennessee to prosecute all of the fraudulent claims that come from around the country to that one Tennessee call center. And that also is not practical. It would overwork or overload that Tennessee prosecutor. And then they would have to bring in witnesses from all around the country for a state prosecution. And that practically it just doesn't work. I mean, I don't
Well, in this particular case, you would have to drag in people from the hospital in Missouri to prove that the bill that was submitted was in fact fraudulent. You'd have to take them over to Kansas in order to testify, wouldn't you, sir?
Yeah, we'd have to take them from Kansas City, Missouri to Kansas City, Kansas, where the case was prosecuted. That is correct.
And to try to wrap this up, as a matter of fact, the defendant, Mr. Rozelle, in this particular case, was in touch with State Farm's Special Fraud Investigation Unit out of Wichita, Kansas, but you didn't rely upon those contacts in attempting to defend this prosecution when you were in front of the Court of Appeals, did you, sir?
Well, I wasn't involved in the prosecution at the trial level, and I'm bound by what is in the record. That was not in the appellate record.
Then, to phrase this correctly, the prosecutor below, which was not you or your office, but you were representing the matter on appeal, I believe. Is that correct?
That's correct. It was a prosecutor out of our office, out of our fraud division.
Okay, so the prosecutor in the Attorney General's office did not attempt to develop a record to show that there were fraudulent acts which had an effect in Kansas based upon the contacts that this defendant in Missouri had with State Farm special investigators in Wichita, Kansas, correct?
Well, I can't say that. I'm not here to critique the trial prosecutor.
I'm sure not.
I believe that the state of the law at the time, as we understood it, and I think as it's plainly written, didn't require this additional restraint or constriction that the Court of Appeals put on it. The plain language of the statute doesn't require that. And what this bill does is simply clarifies the plain language that proximate result means just the ordinary meaning of proximate result. That's all it says. It doesn't add any technical legal jargon. It just says it means any logical effect or consequence.
And of course, Judge Arnold Berger disagreed with your interpretation, and that's why you're in front of the Court of the Supreme Court, correct?
Yeah, the Court of Appeals thought we were wrong. That's correct.
Okay, well, I agree with the Court of Appeals this time. Thank you very much, Mr. Chairman.
Yeah, that's my mute button. There we go. Representative Keither.
Thank you, Mr. Chairman. I really just have a couple of first a question. I mean, how many cases a year are we dealing with in this type of law?
I don't know. I have no way of answering that. It is speculation.
5, 10, 25?
I don't know. I have no way of answering that. I mean, we have 105 counties plus the AG's office that would prosecute. I don't know.
Okay, well then I will then go on to state that it's been my practice over all of the years I've served that when something's in front of court, you let the court make their decision and then you go forward with addressing what you think you need after the decision's been made. So it would be my thought, Mr. Chairman, that this is not an appropriate bill to be putting forward to work at this time. Thank you, Mr. Chair.
Any further questions? Not seeing any. Is there anyone else as a proponent here today? What about anyone who's neutral? I do have listed the Kansas Association of Criminal Defense Lawyers as a written opponent. Is there anyone else here who's an opponent? Okay, well then we'll close the hearing on Senate Bill 60. That is it for the day, committee. I think we have, I don't have it in front of me, but I think 3 bill hearings tomorrow. We'll probably take the full time tomorrow. Originally, we were gonna have 3 today, but I moved one of them tomorrow for scheduling purposes with the conferee. So we'll be busy tomorrow. You're all welcome to come to conference committee at 4:30 as we continue to work on KEMA. And hopefully we can get that maybe wrapped up this evening and get that off a couple of our plates in the next couple of days. So anyway, thank you all and have a great evening. We'll talk to you tomorrow.